Hello and welcome, everyone. My name is Jillian Nelson, and I am with the Autism Society of Minnesota. I have the pleasure of serving as your host today for our discussion about the DHS appeals process, and we are so glad to have you join us. Before we get started, we'd like to make sure we provide instructions to those who would like to hear this presentation in Somali, Oromo, Hmong, or Spanish. If you'd like to hear this presentation in another language, you can find the interpreters by clicking on the globe at the bottom of your screen and then choosing your preferred language. If you can't see the globe, you may have to click on More at the bottom of your screen. We're going to take a moment to share those instructions in each language. Andrea, would you share those instructions in Spanish?
Hola, this is Andrea. Para las personas que hablan español pueden hacer clic en la barra de abajo. Hay una imagen de un mundo y pueden hacer clic y buscar donde dice español y van a poder escuchar al intérprete durante esta presentación. Pueden escribir en el chat si tienen dificultades. Gracias.
Fatima, would you like to share those instructions in Somali?
meeshay more ku qoran tahay tag luuqadda waxaad arkaysaa meesha global ku qoran yahay maapka adduunka halkaasaad taabanaysaa luuqaddaa rabtid halkaas gasho markaas wuu kaaga soo baxaya.
Well, while we wait for Rufa, we will have Mei Chi. Would you share those instructions in Hmong, please?
Nhớ rằng cũng bị hùa mấy chi mùa của ý tu community advocate. Giờ thì có sao nó khó kể lời theo nếu nó cho cái hay luôn mong có yếu trừ sa giá có luôn mouse đồ luôn đi tới bảo để nhớ họ có luôn screen zoom nếu yếu sau ít khó luôn hay thì giờ có sai họ luôn có sao nó lòng的có yếu到sai khó luôn mong nên的zoom tương thiệt cho nên sai luôn mong đâu có有个直播有个直播弄啲地把怎样的可 screen 个到摸个路猫咋到可路摸。
For that. I do want to say many thanks to our team for providing those translations. If anyone joins the meeting and is having trouble accessing the interpreters, we will pause to share those instructions, and we may do this several times throughout the meeting. We appreciate everyone's patience while making sure that everyone's access needs are met. We also have our ASL interpreters who are spotlighted and closed captioning for anyone who needs it. I'm going to introduce our speakers in a moment, but first I'd like to take care of a few housekeeping items. Please keep your microphones off unless you are the presenter. If we are hearing background noise, we will turn a microphone off, so please don't be offended if that happens. Our presenters are going to present a lot of content, but we will try to leave plenty of time for questions. If a question comes up, please feel free to type it in the chat. Our team will be monitoring the chat, so if anyone needs assistance, please feel free to use it. If at any point your access needs are not being met, please let us know and we will do our best. With that, it is my great pleasure to introduce our two speakers, Chad Wilson and Dalaine Remes. Dalaine is a legal advocate and Chad is a supervising attorney, and both are with the Disability Law Center, which is part of Mid-Minnesota Legal Aid. We are hosting this conversation today to acknowledge that access and community-based services has always been difficult, but many people with disabilities and their families are facing much greater challenges using their supports than ever before. When requests for supports are denied, one of the most important tools in our toolkit is the appeals process. So that is what we are going to talk about today. Chad and Dalaine, thank you so much for joining us. I'll hand it off to you.
Thank you, Jillian. I'm just going to share my screen here. Sure I have the right one. All right, can you all see my screen there? Yep. All right. It's
Yes.
just okay. Great. So yeah, I guess we'll start with some introductions here as far as who Dalaine and I are. So Jillian, thank you for that introduction. And so Dalaine and I work for the Minnesota Disability Law Center, and our office provides free civil legal services to people with disabilities on issues related to their disabilities. And so I supervise our community services integration team, which a lot of that work involves helping people with disabilities access the services and supports they need. And the DHS appeal process is a big tool we use when dealing with those issues. Dalaine, do you want to introduce yourself?
Sure. My name's Dalaine Remes, and I'm an advocate with the Disability Law Center, and I actually am stationed in the Mankato office. And I'll tell you just a little bit about the Disability Law Center before we get started. We are federally funded through grants, and we are the protection and advocacy organization in Minnesota. There's an agency like ours, like the Disability Law Center, in every state. And we are, in Minnesota, are part of Mid-Minnesota Legal Aid. So we're under the legal aid umbrella, which is a real benefit to work with other attorneys and advocates who know different areas of the law. We serve the entire state and have an office in Minneapolis, an office in Mankato, an office in Duluth, and one up in Fertile. Obviously, there's both attorneys and advocates with our office. And one thing that's kind of unique about the Disability Law Center is we don't have any income guidelines. A lot of legal aid offices do have some income guidelines. You have to be a certain level below poverty in order to access those attorneys. The Disability Law Center has no income guidelines. And we offer free legal assistance, like Chad said. We really specialize in issues that are related to disability. So we're happy to be here today and to talk to you about DHS Appeals and your rights to file an appeal, and look forward to also answering your questions. So I do encourage you to please include your questions in the chat, and we're saving some time at the end to review those.
This is Nora. Just a couple messages from the chat, just a request to slow down a bit. And then there also is an issue with an Oromo interpretation room. So hopefully we can resolve that just to ensure that there is access for different languages.
Okay, yeah, thank you for that, and definitely let us know if we're talking too fast. Don't want to make the work harder for the interpreters. So if in the chat, if we're talking too fast, please let us know. And then Dalaine, I just wanted to add, as far as highlighting some of the other teams we have at the Disability Law Center. So we have our community service integration team, like I already mentioned, as far as helping people with disabilities access the supports they need, including waiver services, PCA services, things like that. We also have our access and discrimination team, which focuses on people with disabilities that face discrimination in the community from providers or in their homes. So if their housing rights, let's say landlord isn't respecting their housing rights, but again, those have to be disability discrimination to help with those. We also have our employment team, which helps people access vocational rehab services and other supports. And we have our youth services team, which helps youth access from K to 21 if they need assistance with IEPs, things like that, or other plans related to education. And then we also have our rep payee team, which reviews so people that are on Social Security might have somebody that handles their funds for them. That would be a rep payee. So that team reviews the work of the represented payees. And then we also have our voting rights team, which focuses on educating people of the rights during the voting process. So that's just a snapshot of some of the things we work on. Anything you'd want to add, Dalaine?
No, I'm glad you mentioned voting rights because we've been very busy with that grant right now. And the only other thing I'll add is we also monitor facilities that provide services to people with disabilities, including group homes, hospitals, mental health facilities, nursing facilities. And so we have a lot that we do. And I have to say that there's only about 22 of us across the state. So one of the reasons we wanted to do this presentation, number one, is we were asked, and thank you for asking. But number two is we can't help everybody. And so we want to give families and individuals the tools that they need to possibly represent themselves.
Yes, thank you for stressing that, Dalaine.
Yeah.
Unfortunately, with our resources, we can't represent in every single case. And so hopefully we can give advocates and families some tools to maybe better understand this process and represent themselves. But if it is an issue where you might want that assistance, you can still reach out to us, but just know with those resources, we can't represent in every single case.
Yeah, I just want to go through the purpose of this training. We want to educate you, participants who are receiving disability services of any kind, as well as family members and supporting community members and agencies about the appeal process. We're going to review 3 things. One is your appeal rights. Number 2 is how to prepare for an appeal. We're hoping to give you some tricks and traits on how to prepare for the appeal. And number 3 is, what does the hearing procedure look like?
I think I changed the order on this, Dalaine, so we'll just go to talking about the steps to filing an appeal.
Sure. I guess first is if you're receiving services or if your child is receiving services or your loved one, and the county makes a decision to deny you the service or reduce your services or terminate services, they're legally required to provide a notice of action. This is a written form, and Chad's going to pull one up in a few minutes so we can look at it. And the agency is required under law to give you a notice of action. And that notice of action has to include an explanation of why the service is being denied or reduced or terminated. It has to give specific reasons as to why that is happening. And it also has to reference the legal reason, like a statute or an administrative rule or a policy. The notice has to include an effective date of when they want to make the change. And then it also includes about 2 pages of appeal rights. Now, typically, these notices are in English. And so I want to tell you that because if you are not an English reader or you're a non-reader, you need to make that request to have this in your language, or you have a right to request that the county sit down with you with an interpreter and help you understand what that notice of action says.
Yeah, as Dalaine said, I'm going to pull up a notice just to kind of walk you through what you could expect they look like. So as Dalaine noted, the date up there should be the effective dates. And then basic information on your name, if a person has a representative, who that might be, and then a contact at the county. It says lead agency. When we say lead agency, it generally means a county representative, or with some issues, it could be directly with DHS as well. But most of these issues we work on at Disability Law Center involve denials from the county. And so this portion here, it reads programs and services available to you. And this explains what some of your services might be. But then the main spot as far as appealing is this section that says they're giving a notice about a denial. So denial, you can think of that as just being, you're not outright not eligible for a program. Termination would mean you're on a program previously and then it was ended, or proposed being ended with the notice. And then it's supposed to note if there's a reduction in services or budgets. And that's where you can find more information on an effective date as well. And then the county is supposed to check off one of these boxes, noting if it's one of the disability waivers, such as the alternative care waiver or the brain injury waiver, all the way on down, or personal care assistance. And then there's a box there where the county has to explain their reason for it. And if the county is doing their job properly, this explanation section should explain exactly why the action was took place. We notice counties don't always do that. And then further on, there are other check boxes that talk about specific programs, and the county is supposed to check off the boxes as to why the person was denied. For example, if I was assessed for the alternative care waiver, I'm under the age of 65, so I wouldn't be eligible, so they would check off that box. And so that's can inform somebody a little bit more about why the denial took place. And then, finally, I don't think we need to read all this, and we'll talk about the appeal rights further down, so I don't think we need to walk through all those, but just know if you get a notice, you can take a look at that, the notice itself to walk you through some of your appeal rights. And then some other specifics as far as if there's civil rights issues or potential discrimination. And then if you need help of an interpreter, the notice should have these phone numbers on there to request that during the process.
Chad, can I ask you to move up on that
Yeah.
form and make it a little bit bigger?
Sure. Yeah.
And show the an area where it says citation under reason that was denied
Yes.
or explanation.
Legal.
Legal citation. So we have two questions that I'm hoping it's okay to answer right away. One of them is, when do you get a notice of action? Again, the county would send you this in the mail when they've made a decision to reduce or terminate or deny services. Oftentimes it's after a min choices assessment or some type of an assessment or reassessment. So that's typically when you receive them. And then the second question was, where do we find the rules on what should be in the notice? The rules as far as what should be in the notice are somewhat explained throughout the notice. They're supposed to give a reason why the service or program was changed, and they need to include information on that. And so the form itself is kind of explaining the whys. And where do you find the rules on that? Chad, do you have a good, clear explanation on that?
As far as what needs to be in the notice?
Well, they're asking, where do we find the rules on what should be in the notice? Yeah.
Yeah, I want to think, did I have it in this version linked to the statute? Let me see.
It might be in the statutes that we mentioned later on regarding the notice.
Yes, I believe we do have a citation in the presentation. I'm going to go to that quick. Okay.
And just so people know, we will be sending all the attendees a copy of the PowerPoint. And so you will have this as a resource as well.
This is Nora. There's a few other questions in the chat, so I'm just curious. I can definitely keep track. Would you prefer me to ask as they come in, or would you like me to wait until the end?
That's a great question, Nora, and thank you for manning and helping with the chat. I wanted to answer those two because they were really relevant to what we were talking about at the time. And so I don't know if that helps you, but
Yeah.
we could go through a few of these if you feel like they're specific to the notice or the denial or termination or reduction of service.
One, I think we can keep on. One is around the difference between the assessment summary and the notice of action, and then the other is around the statute to where case managers are obligated to provide support on appeals. So that's maybe, again, that depends on when that might show up in your presentation.
Okay. I would say the difference of the assessment summary is that's telling the person or their caregiver what the assessed need is, what they qualify for. And the notice of action is usually the exact opposite. What they didn't qualify for, what was reduced or changed, that's reduced their services or denied them.
And then back to that question as far as, what needs to be in there. I don't have the site offhand. I can, makes me realize I should probably add this if I do any future presentations, but the notice of action is supposed to explain to the person exactly what steps the county is taking. This guide to filing an appeal kind of, noting, it outlines it, but I can dig up as far as the specific citation. I don't have it offhand. But it's got to inform the person of what action is being taking place, when the action is set to take place, and then they are supposed to provide those specific reasons for denial. And so, with that, if they're doing their job properly, they should be citing statute and policy specifically. But if not, that could be an argument in an appeal. But I mean, if looking at the notice, you can basically tell what the issue is. I mean, I feel like a judge is still going to hear the issue, but could be a good argument there as far as, why the notice is invalid for letting the person know about what step is being taken. And Dalaine, do you think it'd be better just wait to questions till the end?
I don't know. Some of these early ones I thought would be good just because the notice of action is kind of, the determining factor around myself or my child is not going to get the level of service I've been getting previously. They're changing something. But I'm happy to do it, whatever you think.
Yeah, we can do questions. I just, I worry we might not hit everything, or, there'll be questions that are answered later.
Okay.
But yeah, I mean, if you want to watch the chat and you feel like there's some in there, yeah, we can do that.
Okay.
Yeah. And then, yeah, anything else to add as far as the filing of the appeal, Dalaine?
No, and I can't see the presentation at this time.
You can't? Okay, let me, strange. What do you see?
Just us.
Oh, really? Okay, let me
Two
go back.
interpreters and you and I.
Okay, let me go back. I was switching screens.
That's all right. And I think that happens sometimes when we search for something.
All right, you see it now?
Yep. Okay. So yeah,
Okay.
that kind of covers the notice of action. I did get the question about the case manager helping somebody appeal. I'm just going to give you the attorney answer and say that depends, and we'll talk about it. Next slide.
Okay. Yeah, so we can move on then and talk about, so you got the notice, and you disagree with it, right? And so how do you file the appeal? This is more of a procedure thing. And so the first thing, to caution though is if you want to file an appeal, there are specific deadlines that apply to file the appeal.
Hi, this is Maren. Let's just pause for a minute here. I think our Oromo interpreter left and then came back in, and she is not assigned interpreter function right now. So let me just take a moment to fix that. And I'm sorry for the problem.
Yep, no worries. Just let us know when you're ready.
All right, I think we should be good to go now. Sorry about that.
Sure.
Okay. Yeah, so the deadline to appeal, and this is very important because if these timelines aren't followed, you can risk losing that ability to appeal the action that the county is taking. And so the standard timeline is, so we're talking for most issues, particularly with waivers or PCA, it's 30 days after you receive the notice. So the key thing there is that date where you go to your mailbox and you open up, let's say the county sends you a notice of action in the mail. The day you go out to the mailbox and open that up, that's when that 30-day timeline or clock starts. And so it's very important to keep that in mind. Now, there can be instances where maybe you missed that 30 days. If it's beyond 30 days, let's say it's the 31st day to the 89th day. If it's beyond this, then you can still appeal, but you have to have a good reason, which under statute is called good cause. And so this is a broad statute. This could be an instance where maybe you're ill, a family member is ill. It could be maybe there was a death in your family, things like that. It could also be, maybe you never received the notice, but there is a section there that does leave it up to judges to their discretion if they find it's a good reason as to why you didn't appeal in time. And so with this, you want a specific reason you missed the timeline. Saying, I just forgot, is probably not enough to show there was good cause. Now, if it was, I forgot because a family member passed away or something like that, there could be something there. So it's very broad. But what's important is after you get past this 90 days, based on federal law and state law, after that 90 days, you can't make any arguments to the judge. You probably won't be able to appeal in if it's after that 90 days. And so that's it as far as the timelines. I want to stress that. And so, another thing I want to stress as well is that, with these, counties are supposed to send this notice of action in writing, letting you know they're denying something. But Dalaine and I are seeing some counties out there are not sending these notices of action like they should. So some of those, they might be denying with an email or over the phone. And if the county doesn't send that notice, you could technically still appeal. But in most cases, we suggest people ask the county for that notice to appeal, so there's no questions about that timeline. And so now let's get back to the logistics of actually filing the appeal. And so there are many different methods. There's a DHS online form that's generally what I use, just because it's pretty user-friendly and easy to use. But there also can be, you could do it by mail or fax, or the online portal as noted up there. Now, with any of these, if you submit the appeal, we suggest, let's say you fax it, keep confirmation that the fax was sent. If you use the online form, we always suggest people take a screenshot of that, just so you have that clear record. And then if you don't hear anything from DHS after, let's say, 2 weeks or 3 weeks, or let's say 2 weeks, then follow up with DHS and ask what the status is. And as we go further, we'll have more specifics there. And so now I'm going to open up this DHS form that we usually use for this. Just give me a moment.
I just want to stress while Chad's opening that up that if you do, again, if you do need interpreter services or something in a different language, or you're not understanding it, ask for help. And the county is required to be you know, accessible to all of us. And they're supposed to be, you know, sensitive and helpful to all of our various cultures in the state of Minnesota. And so it's important if you need or want an interpreter, if you need to meet with the county because you don't understand something, that you ask for that and let them know you either want an interpreter, want a face-to-face meeting, or even a phone call with an interpreter, so that you can get things explained to you at any time, or if you need help with those things.
Thanks, Dalaine. And do you see the form here now?
No, it says appeal to state agency. It looks like you have to click.
Yeah, no, that's right. Then yeah, that's
Oh,
where I
good,
wanted
good,
to
good.
go.
Okay.
Yeah. So this is the first screen. So here we can go back. So you can complete it electronically or you can do it by hand. And so I like
And they're the same form. Whether you
Correct.
print it
Yep.
out and complete it or whether you do it online, it looks exactly the same.
And we'll talk later about how you can get this form in different languages if you need it as well. And so first one, pretty easy, you know, appeals about you or somebody else. And so with this, DHS will ask you, so let's say you're trying to file an appeal for your son or daughter or somebody else you know. And with that, so for example, if it's an adult that's under guardianship, let's say, it can be helpful at this point to submit that information showing that you are the person's guardians, that you have, you know, that permission to submit this on their behalf. And DHS asks for this. If you have it handy, it is good to submit. But let's say you're gonna have issues getting that, then I would say skip that form and you can at a later date send that to DHS to make sure they know you have that, you know, authority to submit that appeal for that other person. And then, you know, lots of questions here as far as describing who you are. So obviously I'm an attorney because that's who I am. You know, generally you're going to say for a person. And then, you know, the big parts here are all the parts that are required. Absolutely fill those out. But if you're not sure of, let's say, a case number or a PMI number, I tell people leave that blank. That's not a must. You know, the main thing is having, you know, you or your child's name or your friend's name to be correct. And then the addresses, all that stuff. So you know, just want to highlight that. And then the section of, you know, moving on, it asks about agency. And so, you know, for example, let's say I live in Hennepin County and Hennepin County told me my PCA hours are being cut. I would write, you know, Hennepin County right there. And then if you have that date from the notice of action, that's helpful to have. But if you don't, it's not required. You can leave that blank, but you might have to deal with that at a later date with the appeal process. And there is an option to submit that notice. If you have it, submit that. But if not, you know, it's not a must, but it can help with the process. And then the big thing is asking which program or type of benefit is the appeal about. You know, with this, you want to be as clear as possible as far as, you know, let's say you're on a CADI waiver. It could be, you know, CADI waiver, CDC, Community Consumer Directed Community Support, CDCS, or PCA/CFSS, something like that. And then, so you want to be specific with that. And then, you know, in the section about explaining why you disagree, don't feel like you have to have your whole argument there. You know, so it could be, you know, my waiver budget was reduced following a MnChoice's assessment, and I feel the assessment doesn't properly reflect my needs. Or it could just be, I disagree with the reduction of my PCA hours. And so you want to be specific here, but don't feel like you have to present your whole argument. You know, as far as maybe I haven't had that time to look through all the assessments and know exactly what you disagree with. Just be clear that exactly what you're appealing, but you don't have to have your whole argument there. And then DHS does have this section here where they say you can attach documents you'd like the judge to see. Now, at this stage, when I'm submitting an appeal for somebody, I generally don't submit anything because I still want to look over the documents, and there'll be other steps I can take later to give information to DHS. So, Dalaine, do you usually submit documents?
No, I usually, same thing. I fill out the request for the appeal. I try to make it simple and make sure I include the right service. And I don't submit any documents until later on when I'm submitting evidence.
Mhm. Yeah, and so you don't feel like you have to have your argument ready. I know if clients have contacted us and they explain the reason and it's like a full paragraph or multiple, you don't need to do that, at this stage. At the hearing is when you can, and prior, submit that information. But I mean, if you have documents you want the judge to see right away, I think that's fine. I'm just explaining our process, how we do it sometimes. And then there's a question about continued benefits. And so you'll see that caution here. If you lose your appeal, you may have to pay back some or all of the benefits you've got. And so technically in statute, that is a possibility. But talking specifically about waiver funds, things like that, I think between you and I at the Disability Law Center, we've never, Dalaine, we've never seen a county go back and ask for those funds directly, right?
I have not. I've been here 14 years, and for an individual who's, maybe qualifies for medical assistance, they're low income, maybe they're getting Social Security benefits. I've never witnessed a county seeking money to pay back the services. So, typically, if you need the supports or you need the service in order to function in your day-to-day life, we usually encourage people to make sure that they check, I want to keep my benefits at the same rate now until my appeal is decided.
Yeah, and what I'll caution with that is I think PCA hours, but again, I don't think that's happening now. I have seen where they've had to maybe reallocate their PCA hours throughout the year, but that's the only thing I've seen. I've never seen any direct payment return. Now, technically under statute, to have the benefits continuing, it's supposed to be within 10 days. But if it's past that, I have seen instances where the counties grant that anyways. So, I agree with Dalaine. I usually encourage people to check that box off. But again, we can't promise that if you check that off, they can't ask for that because technically they can. But we'll just stress in our experience, it's unlikely, but still a possibility. So, caution you on that. And then there's a question about emergency appeal and do you need to appeal faster? Generally, I don't check that off. I think I've only checked that off when it was like somebody getting improperly thrown out of their 245D 4-person group home and at a pace that just didn't make sense. But in general, if it's a budget issue or PCR issues, generally I don't check off that box. Do you use that box much, Dalaine?
I haven't, but I think it's important for people to know if there is any circumstance where the person would have to be hospitalized or that would be a serious risk of health and safety if their services weren't continued, to check yes would be fine.
Mm-hmm. Yeah, and I mean, and with this, I mean, if you're unsure, you can probably check it off, but just know they might not, provide that emergency appeal process. And so the other issue, as far as asking for interpreters, with this form, you can ask for that specifically. So, and then ask for preferred language. So definitely fill that out if you do need an interpreter. And then, looks like they have quite the list, but if it's on the list, hit other, and then it will ask for you to type in what the language is. Similarly, if you need an accommodation for it. So this could be a section asked for an in-person hearing if that's something you need because of a disability or other special arrangement. And then, just this, ask who's representing. So if you're the person representing, then, fill that out. And then way to sign it down here, letting you know you agree it's all factual, and then you can hit submit, and then you don't get emailed a notice or anything like that. So that's where we say take that screenshot. So I know we spent a lot of time here, but I think this is a step that's important that we, want to make sure we talk through people and make sure they understand that. So I don't know if there are any specific questions on the appeal submission at this point.
I just want to add that I think it's important to know that you can represent yourself, or a family member can help represent you, a friend can help represent you. I've seen and witnessed case managers helping people with an appeal. I've also seen case managers who don't agree with the client refuse to help with the appeal. So I've seen both of those. I know there were some chats about that, and we can talk about that later.
Yeah, and I think what I would argue with that is, I mean, argue, but the main thing would be is if you need help to file that appeal, the case manager should at least help you with that process. Beyond that, it might be tough, but I mean, if somebody generally needs it, I would say it's, as you saw, if it's a form, somebody should be able to help them out with that process, right?
Yes.
And so, yeah, I think that covers it. I think we talked about that a little longer than I planned, but I think it was good to walk through that specifically because, filing that appeal can be intimidating for sure if you've never done it before.
This is Nora. There is a question around how far in advance of the appeal can you submit documents and evidence. So I feel like that does, if that fits into what you're talking about with a submission, that one might be appropriate.
Yeah, sure. So we will get into submission. I mean, there's no set timeline for people appealing. There's no specific timeline in statute for submitting evidence. So this is probably the earliest step would be, when you're submitting the appeal, if you want to submit it at that step, that would probably be the soonest you want to do it. But as far as practically speaking, which we'll get into in a little bit here, I usually, since there's no set timeline, a lot of times, you want to do it at least a day in advance, maybe two, just so you can hope that the judge reviews it. But how do you handle the submission usually, Dalaine?
I usually try to get things in. I think it says, I want to say it says 4 to 5 business days or 3 to 4 business days. So I usually try to abide by that and get it in earlier. And then we also need to send evidence to the county or the agency as well.
Mm-hmm.
So
yeah, we'll get into that.
Yep. So we'll talk about that as we move on.
Mm-hmm. But yes, I mean, just a basic. I mean, this is the soonest you can submit is with that submission. Because once you're submitting it, then DHS will create that. They'll. Well, I guess we'll get. Yeah, this slide sums it up well. So they'll send out a notice then with. They'll include a docket number, which is basically the number DHS uses to identify your appeal, and then it will also contain the name of DHS Human Services judge. And like I said, those are sent by mail. And then usually after submission, it's about 30 days after you submitted the appeal that the appeal hearing is set for. And so, yeah, usually have a specific notice of the hearing. Now, in some cases, if the judge needs more clarification on what's being appealed, they might ask for a pre-hearing conference, which is a phone call where the judge will chat with the person appealing in the county to maybe clarify what the issue is. And so again, if you submit an appeal and then 2 weeks after, let's say about 2 weeks after you haven't received a notice, then at that time it might make sense to reach out to DHS to make sure it was received. That's particularly important if you're closer to that 30-day deadline to appeal.
This is Jillian. I just want to let you know that we are not seeing any slides.
Oh, okay, thank you. Sorry, back and forth, different documents.
Yeah.
I'll do it right now. I will go back then. Moment.
I think we're on the guide to filing an appeal.
Yep.
Step 3.
That's not it.
Just
There we
2
go.
down from that.
Got it now?
Yep, we can see it now. Just got to get to step 3. There, one more up.
Yep.
There you go. Yep, that's
Yeah.
what we just finished.
Yeah, after filing the appeal. So, yeah, and then you also, if you haven't received anything, and let's say you're talking to your case manager, there are times, let's say just by chance you're talking about something else prior to the appeal, you could check in and see, hey, have you received, notice of my appeal, just to, make sure it's been received. And then, yeah, now, again, the DHS appeal statute on issues that can be appealed, it's pretty long. And so we're just highlighting some of the issues we see and, things that potentially can be appealed. And so, first one would be is medical assistance waiver eligibility. And so for each waiver, there's a certain level of care somebody needs to receive to access a certain waiver. And that's, we see counties deny services from continuing because they determine the person no longer meets that level of care. So that could just be outright eligibility for the program. That could be many different reasons. Another common appeal issue would be PCA, or now Community First Service and Support hours. A reduction in those hours can be, or just an appeal outright if you disagree with the assessment. And then home modifications, that's something that can be covered under certain waivers, depending on what the support is. So it could be, maybe somebody needs a ramp added to their home, or a ramp added to their primary vehicle. It could be, we've seen in the past fences in backyards to maybe a child that elopes or an adult that elopes. But just caution, home modifications, these are changes to the home to make it more accessible. If somebody needs new siding or new shingles on their roof, DHS policy probably wouldn't support that. So I don't know if you have anything to add on any of those, Dalaine.
No, I would agree. The home modifications are modifications to what already exists. So sometimes we get calls and parents or a person wants to get home modifications, but they want it to be to fix a flooding of the basement or to add a new addition. And the policy and the statute, is aligned with the federal guidelines, and that's just not allowable. So you have to think about how to improve the current environment to make it more accessible or to modify it. And the assessed need has to be there. So most people get an evaluation of their home to see what's needed to make it accessible.
Yeah, and then, the next one, which I'm sure we see a lot of these, so maybe many of you here today have experienced this. So appealing a consumer-directed community support budget. So somebody's, let's say, under the CADI waiver, a CAC waiver, DD waiver, and they want to go with this program where they receive a budget, but they have more flexibility than with traditional waiver services. So this is a big one of something that could be appealed. Now we could probably do a full presentation just on CDCS budget appeals. I'll be honest, it's a pretty confusing process of how they calculate the budgets. So I'm trying to think of a simplified way to talk through this. Yeah, Dalaine, maybe you want to talk about the non-emergency medical transportation. I'll pull up something on the DHS website.
Sure. Non-emergency medical transportation is a service for people who are on medical assistance. If you don't have access to public transportation, or if because of your disability you can't access public transportation, individuals can get approved for non-emergency medical transportation, which is oftentimes accommodates a physical disability. So they have like a lift or a ramp to enter the vehicle. And you can access that for no cost if you're on medical assistance to get to your medical appointment and back home. And there's also, underneath the same statute, if you are transporting somebody with a disability who, again, can't access public transportation to get to medical appointments, you can get reimbursed for your mileage. So non-emergency medical transportation is a service that counties don't often tell people about, and I like to highlight that. Because we do get cases where people are not approved for it, and we have filed appeals and been very successful to determine eligibility for that service.
Yeah, thanks, Dalaine. And then, back to CDCS. So DHS has a very complicated system or methodology they use to calculate CDCS budgets. And so that complicates how you can argue related to CDCS budgets. And so each budget might have slightly different variables. So I'll pull up the DD waiver right now. And we'll have links to this information. And so, with this, how they're calculated is that DHS looks at certain variables, and then each of those variables have a different weight or score that determine what the budget is exactly. And so with these, I'm not going to cover each and every variable, but you can
make
look
it
at
a tiny bit bigger, Chad?
Yep, I was in the process. Yeah.
Perfect.
Yep. And so with this, so it has this formula, and it can be pretty confusing. You have to weight as as far as how much they're worth, like levels of supports and services. There's a definition, another part of the page that explains what these are exactly, but you have brief definitions here that needs 24-hour plan of care. That would just mean that you need to have a plan in case if something goes wrong. They have to have a clear plan of how they'll be supported throughout the day. And then awake supervision. This is some examples of things they look at. Some of these are not well defined. So this is for the DD waiver. And so this looks at needs for physical supports, and they'll define each one. Need for mental health services, that's a yes or no. I've seen that one where people have been misassessed and the county just missed that. So that could be an important one if that's marked as a change. And then other more specific needs as far as things like epilepsy or seizures. And then, the biggest ones we see are related to maybe supports for these different areas. And so I don't want to belabor each one of these because I could talk about these for a full presentation themselves. But I just want to highlight this for folks so you don't get caught in the trap of, well, I'm appealing the budget. And going to judges saying, hey, I want more of a budget. You got to clearly be able to look at the DHS's algorithm and make those arguments, because without that, unfortunately, a judge is probably not going to rule in someone's favor. And so CADI waiver is a little different where in CAC and where they look more at needs for physical assistance. So anything you want to add to that one, Dalaine?
No, just that these aren't very fun. These appeals are not very fun when you're looking at CDCS because it is so complex. I think my biggest message for attendees is you cannot just say the budget's not enough money for me. You really have to identify what service was on the last budget or how something was measured the last time, and then how the county miscalculated that during this assessment. And that can be difficult to do, but you have a right to request your assessments. And then what I do is I lay them down and I compare and contrast. Where is it that the county got this wrong compared to the one they did last year? And then go into the policy and kind of look at and identify, was the county wrong or right? And then can we prove that they were wrong?
Yeah, thanks, Lane, for focusing, because adding even more confusion is that DHS doesn't specifically provide all these, or the counties don't provide the specific scores. So it does require looking at the current assessment versus last year's assessment to identify why that change took place. again, that's for a change in budget. Now, if it's the person's first time, it might get tougher, but then it's still looking at assessment to see, well, which one links to these areas and see if you disagree. So not the easiest way to appeal, and any of these issues, try to reach out to other people that maybe might know the process better, because I've gone through this a few times, but I still have to go back and look at the list again to figure out what happened.
Yeah, I just want to say, and you can ask them for a complete explanation. And if they don't provide you with one, you can ask again. I want to know exactly what was different. Some of the counties, will are able to understand that. I got to admit, sometimes the county agencies do not seem like they understand themselves. So, it's a crapshoot, because it's one of those assessments where if they click one number, that something comes down, and then they pick from those options. And so if they make a mistake up here, you could lose a lot of hours or a lot of services just because of the way the assessment is laid out. So push the county to give you a clear reason why it was changed.
Yeah, thanks, Dalaine. And then one other thing I'll mention is our office helps with these far too often would be people can appeal when, let's say, somebody lives in a 245D group home or other 245D.10 services. They can appeal that action with the DHS appeal process as well. So I won't dive into that too much, but it's just helpful to know that could be another issue that could be appealed. And again, this is just a list of some of the areas. The statute itself has many other examples in there as well. For example, you could appeal, let's say the state denied prior authorization for a medication. That could be something else that could potentially be appealed.
And let me just say, Chad, we talked about this earlier, but if you ask for services or ask for increase in your PCA services or ask to change to a different waiver, and the county just blatantly ignores you or does not act, it's also appealable if it's not acted upon. So if you're ignored, you can literally say, I've asked for this 4 times, you're not responding, send me a notice of action. And if they refuse, you can file an appeal and say they won't send me a notice of action and they're ignoring my request for services.
Oh, yeah. And then, kind of moving on, the bigger thing would be is, like Dalaine said, these appeals aren't fun. They aren't easy. And so want to kind of put home reasons to appeal. If you just disagree with the county and want your story heard, that can be one way with this process. But at the Disability Law Center, this is the process we look at as far as deciding if we represent or not. Because our resources, we can't always can't take on every case, of course. So the first thing would be is you receive that notice of action you disagree with, or like Dalaine said, the county has just continually said no in other forms. But if possible, get that in writing somewhere. So this would be you're denied a service, or the service is reduced, or completely terminated, or there's other errors in the assessment that impact eligibility. And so it could be an issue where it's first time being assessed for services. You can disagree still. But then the main thing would be is you need to have a legal argument that's likely to be, that has some chance of being successful. And that can come in many different forms. But 3 that come to my mind are that the county misapplied policy or law. So, for example, maybe the county reduce somebody's PCA hours, and they said you don't need support with it. Let me think here. What's a good example of this? So you're assessed for PCA hours, let's say, and DHS denies it, and you notice that, or the county denies it, and you notice the county miscalculated. That would be a good example of a misapplication of policy or law. It could be the assessments recording incorrect facts, and if you clarify those facts, you could get to the point that showing that the county is wrong. Or it could be citing a state or federal law showing that the agency took an improper step. So these are things to consider when appealing to decide, is this something worth appealing? Is it likely to result in the outcome I'm seeking? I mean, main thing is do you have a legal reason to appeal? Like Dalaine said, if you just go to the judge and say, I want more PCA hours without more specifics, it's probably not going to be successful. But again, we can't know for sure unless we know facts of a given case.
And I would encourage people to look at the notice, because the notice will give you the reason that they denied the service or terminated or reduced the service. And so use that to look at, were they right? Is that accurate? So.
Mhm. And then, continuation of that, I put this separate out into 3 areas that I think are important to keep in mind. I mean, the first 2 are easier to answer in my view, as far as what are you appealing exactly? Because that's important, because then you'll know, if you know what action you're appealing, you'll know which policies you might want to look at or ask for, if you don't know where to go. And then what outcome do you want? Knowing what outcome you want is critical, because in appeal, have to sit down and think, well, the outcome I want, is it even possible to get that? For example, I think one you and I have talked about before, Dalaine, is that maybe somebody's authorized for homemaking services, and the county just can't find a provider. The county is taking all the steps they can to try to find a provider, but they just can't find one. You're not going to be able to go through the appeal process and require a provider to provide the service. Anything you want to add to that one, Dalaine?
It's just really, really difficult right now with the workforce shortage. And yeah, the outcome you want is you want the service, but if the county has evidence, and oftentimes they do, that they're calling providers every month and they're emailing providers every month saying, we have this many people who are needing chore services or homemaker services. Do you have any staff? And the response from the 18 providers is, we've been posting and hiring notices every week for the last 2 years, and we're trying to hire, but right now we don't have any extra staff. If you put that in front of a DHS judge, I don't think he'll really be able to rule one way or the other, because the county will show they're making efforts, and it's so the fault is kind of something that's out of our control, which is terribly difficult at this time, and we understand and know that that's happening.
And again, this is based on our experience with this process. We can't say definitively how a certain case might end up. And then, what outcome do you want? Just back to that. What's important about that is then it can help you review policy and see if it helps. And then also, it's as you go through the appeal process, keep in mind that outcome to help have it be more of a straightforward process where you know what you're working towards. And then the harder one would be, does DHS policy or law support the outcome you're seeking? That's one where, if you're not sure, it would be to connect with other resources that might be able to help maybe explain those issues to you. For example, if we can't represent a case, we might give people advice as far as, is there maybe a policy that supports what they're seeking?
We're going to talk about some of those resources in a little bit too.
Yep. And so, let's see here. Dalaine, I'll let you take this one.
Sure.
Yep.
Sure. So for the Disability Law Center, before we, even if we accepted a case to advocate on your behalf or to represent you, the first step we always take is to try to negotiate with the county. The reason that we do this is because it's a lot quicker to try to resolve the issue in 2 to 3 weeks by negotiating with the county than it is to wait, to file an appeal, wait 30 days for the date of the appeal, have the appeal hearing, and then wait another 30 to 90 days for a decision. That leaves you without those services for a long time. So especially if the facts are strong, we try to negotiate with the county, and we encourage you to do that. So Number one, if you don't understand something, ask the county for a written explanation. If you are, again, a non-reader or your loved one is a non-reader, or you need it in a different language, either you can request to have things in another language, or you can request to have further explanation to meet with the county. You can ask the county to reconsider the action, and you have the most success to get them to reconsider if you have some type of evidence. I mean, let's say they say you didn't qualify for the 16 hours of PCA services because you answered one question by saying you don't need any mobility assistance. However, that's really not the case. And on that day, you just made a mistake and answered it wrong. You need the same mobility assistance as you needed last year. And so maybe you can get a letter from your doctor, or you can get your last physical therapy evaluation and give the county something that says, you know, that wasn't accurate. This is accurate. Here's my medical documentation, or a letter from my mental health provider saying that, that I answered that wrong. This is what my need is, and seek reconsideration. You can ask the county to give you a copy of the specific statute or administrative rule that they reference, which honestly can be really helpful if it does end up in appeal. Because then you've got the legal statute that they're using, and you can try to, you know what you have to prove in order to win. You can also ask the county to meet with you and, like I said, explain their actions and answer your questions. So there's ways to negotiate with the county, and we encourage you to do that.
And I will just add, you know, there are some counties out there that, you know, once somebody files an appeal, they say, go with the appeal process. We're not going to talk to you. You know, we disagree with that tactic. You know, it can be county by county, or, you know, county worker by county worker. So I just stress that, I mean, even with these, the county might not be, you know, helpful with that, but we do see a lot of counties that are willing to at least talk to you on these issues. But, you know, I just want to stress, don't be surprised if you do have a county tell you we're not going to talk to you until the appeal hearing, which is unfortunate, but just want to stress that.
And sometimes the notice of action will say, we could approve this, but we need more documentation from your doctor or from a therapist, or I just ask that people take that to heart. Try to make an effort to get the documentation so that you can get those services implemented sooner rather than later.
Yeah, thanks, Lane. And, you know, another thing I'll add with why we like to negotiate is, even if we have the strongest, even if we feel like we have one of the strongest cases ever, you never know how a specific DHS judge is going to view a case. And so that's why if you can get it resolved on the front end, it can be faster, and it you know, it can just be, it also can be helpful to foster a better relationship with the county as well, if you're able to resolve things and they you realize you're willing to talk things out with them. And so you're not going to be able to resolve every single case with negotiating. And so, you know, some of that, having a meeting or asking for citation,
Hadda
to me,
wuxuu ka
that's,
hadlayaa marka county-ga appeal-ka. Oh, you guys can hear me?
Yep.
yeah. Mm-hmm.
Oh, I'm sorry. I'm supposed to be in the Somali room, so I apologize. Thank you.
That's okay.
Sorry. Keep
Do you need a moment to switch that over? Okay. And so, yeah, Dalaine, if you maybe want to walk through, you know, some of the steps we usually try to take when we're preparing for hearings.
Yeah. Again, I think the important to make sure that you know what the county is denying and why, or what they've reduced and why. And then look. Oops, I think we have. Can everybody mute your phone? Oh, okay. So I asked, we usually review the community-based service manual, which is online and fully accessible, to look at what are the qualifying factors for that service, what's the criteria to be eligible, what really is a service supposed to do, and think about how you qualify or why the county was wrong. And then we gather documentation or evidence from your medical providers. Sometimes it's really helpful if it's a child to get an IEP from the school, because if the school is providing those services, then there's a little bit more evidence that the child does qualify for services outside of the school as well. Any assessments or evaluation and written evidence is key to get it in writing. And then you want to think about witnesses, people who support your position, people who agree with you, who might testify at the hearing or write a letter. Oftentimes, medical professionals may not be able to testify at a DHS hearing, but they'll write a letter or they'll give a copy of an evaluation or assessment that you can use as evidence. We ask people to make an outline of their arguments and focus on the main facts. If you don't write it down, sometimes those appeal hearings can be stressful. Even I get nervous when I'm doing appeal hearings. So to write down an outline of what's your main points, what are your main arguments to prove and to show that the county was wrong and that you are right. And then you'll receive the county appeal summary. It's got to be sent at least 3 business days before the hearing. And you can review that, and sometimes that can be helpful, kind of can trigger you to see their point of view, and then maybe again gather additional evidence to prove that they're not accurate and you are right.
Yeah, and I'll just, I really want to emphasize the written evidence, which, I know it can be tough to get that documentation, and, just unfortunately, a judge is generally not just going to take your word for it. They'll want information from medical providers. Anybody with those extra titles by their name can be really helpful to have letters from folks. And so the more written evidence from different providers in different areas you can have, the better. Just relying on your own testimony, it can be difficult to be successful in appeal then. You want other information supporting what you're testifying to. And then I'll add the county appeal summary, what that is. I just want to make sure I was clear on that. What that is it's the document the county sends out where it includes all the information the county is going to rely on at the hearing. And that is supposed to provide a basis for why the denial took place. And so that's why it can be really helpful to review that. And a lot of times I'll, which we'll get into this on the next slide here in a little bit here, so I won't jump into that. But just the preparation. I found that some providers can be more than willing to write letters or even act as witnesses, doctors or therapists. Main thing would be is if you want that, ask as soon as you can. And then
one more thing I'll add to that is one way to think about a different way to think about it that can help you in the appeal is to ask your providers and to think yourself, what's going to happen if my son or daughter does not get this service? What's going to happen if I don't get this service? What's the risk? Am I going to have increased hospitalizations? Am I not going to be able to leave my house to access my community? Is my health and my safety going to be at risk? Is my independence going to decline because I'm not able to work with my PCA or work with my independent living skills specialist? So what's the risk if you're not going to get the service is also kind of a good point to make.
Yeah, and then I feel like we're start a little bit late, and then want to be respectful for people's time. So try to cover these next few pretty fast as far as other steps. And so if you're unsure as to why, maybe you're unsure about policy or what policy to look at, or you think what the county is doing doesn't follow DHS policy, DHS does have a form where you can submit questions to them, the public can, to ask for clarification or what the specific rules are. And then DHS also does have an appeals archive where you can look up prior DHS cases with the appeals division. And that can be helpful to find similar cases to bolster your argument, to support your arguments. The big thing would be is that judges don't necessarily have to follow what the prior case said. It's not like it's not like a state court or anything like that. But it still can be helpful to support your argument because we do find that persuades the judges often. And then Dalaine, you want to talk a little bit about regional resource specialists?
Sure. There's you can also call the DHS regional resource specialist and ask them for technical assistance or clarification on the policies or the statutes. I think both contacting the online form for DHS and the regional resource specialist, if you can get an email address and ask them the question in the email, have them respond in writing, you can actually submit their response as evidence to the appeal if it's supportive, if it's agreeing with what you're trying to prove.
And then I'll just add quick as far as the appeals archive. It's not the easiest to search for, but if you have the time, it can be helpful because you can search by waiver type and in keywords. And then I'm sure there are questions, but well, what can I submit? So thankfully, these appeals aren't like it's not like a district court case or criminal court case, right? And so all evidence commonly accepted by a reasonable person in the conduct of their affairs as has probative value with respect to the issues. So yeah, a lot of words there, but at its most simple, most evidence that isn't repetitive will be accepted into the record. As long as it is information that directly relates to the issue at appeal. And so that's just helpful to know is that you should be able to submit most documents. Now, just because you can doesn't mean you should submit everything. It's helpful to really narrow down and focus on the information that's most directly related to your appeal. You don't want to overload the judge with too much documentation. And as far as what can be accepted or not, at the beginning of a hearing, a judge might discuss that a little bit as far as if there are issues between the parties about a document being submitted. The judge will have a conversation about that and figure out if they will accept or not the documents.
I'll just add, we want to focus on the legal issue for that evidence. And we understand that by the time people call us, oftentimes they're frustrated with counties. And there's been kind of a ongoing conflict. Judges will respond much better if we stick to the legal issues and don't submit 25 pages of argument emails with the county. So my old supervisor used to call that stay out of the weeds and stick to the legal issue, the services that are needed.
Yeah, I think that's a good point, Dalaine. I mean, it's also a big thing where, if the hearing just turns into complaining the whole time about the case manager, but it doesn't directly relate to the denial, it just can distract the main points. I like that. Stay out of the weeds. And then kind of move. So let's say you have a witness that doesn't want to attend the hearing that you really want there, or they're not giving you documents. And so there's a way that somebody can be required to appear at a hearing, and that would be a subpoena. And so I would caution, I would only use this if you feel it's a witness that is absolutely essential, because you run the risk if you force somebody to appear, it can make it less likely they're going to be on your side at the hearing, no matter what their opinion is, right? And so, but where I found it helpful though is I have had instances where I talk to a professional or a provider of some kind, and they say, "Well, I want to appear, but my employer said they don't want me to appear." Well, a subpoena could be one way to get it so that person can appear, and then they can still say, "Well, I have to be there," to their boss. So that can be helpful. It can also be helpful if you need specific documents. Similarly, you have a right to your whole case file from the county, and so if they're not giving you that, you can similarly go through this process and let the judge know you're seeking that information. And so if you need this, I'll be honest, I haven't subpoenaed too many witnesses, But if you want that, contact the judge and let them know you're requesting it. And be ready to explain exactly why you need the witness there or why you need the evidence, and then have the name and address of that person or where that evidence is located. So that can be another option we like to make sure people are aware of. And then talked a little bit about submission of evidence. Dalaine, do you want to talk about this one?
Sure. I want to get to questions, and I
Yeah.
know we're running a little behind. You can submit your evidence online, or you can fax it, or you can email it. So 3 different ways. When you get the notice of when the appeal is, the date and the time, it'll give you the judge's name and the contact information and some of these instructions as well. I often advise people to make sure their outline of their arguments or your main points kind of matches your evidence. And so when you're testifying at your hearing, you'll be able to talk about your main points, but you'll be able to say, you can see that in the nursing assessment on page 3. Or you can see that in, the letter that my doctor submitted. So you can refer back and forth between your main points and your evidence.
Mm-hmm.
You also have to submit them to the judge and to the county or the agency. And there's no set timeline submission for the appellant under statute, but it's, I think it's preferred to get it in, 3 to 4 days in advance so the judge can review that before the hearing. But sometimes we don't even know if that happens. So
Yeah, and then, I'll just riff off that one as far as, if the county hasn't sent out their appeal summary, I usually wait for the county to submit their information first. Because that way, I can know if I'm submitting that same document, we can, we don't want to overrun the record with the same document if the county already submitted it. And so I generally would wait till after I get that appeal summary. But not a must. It's probably better in cases to get it done sooner or later so you don't forget or run out of time at the end.
I'll just say one more thing. Sorry.
Okay.
If you have multiple documents that you're submitting as evidence, it's really helpful to make a cover sheet and list what those are and make sure you use page numbers. You want to make it really easy for the judge to know what your main points are, to know what you're appealing, and to know why you're right. And so my old boss used to say, pretend like the judge is a 12-year-old and you're explaining to them why you're right. And no disrespect to the judges. They're definitely not 12-year-olds, but it just makes you kind of really think about, I want to explain this easy, and I want to make it easy for them to review my materials.
Mm-hmm. And then I'll quickly hit this. This is just how to contact the DHS Appeals Division or the judge. It's kind of repeats some of the stuff that's on the prior slide as far as submitting evidence. But one thing I'll caution is if you give the judge a call and if you want clarification on the hearing date, or let's say you need a different hearing date or something, that's fine. But if you reach out to the judge and want to say, Judge, my appeal is right because of this, the judge is not allowed to discuss those details unless somebody from the agency is there as well. So just want to caution that. And then another thing would be is in these appeal hearings, it's this burden of proof. At its most simple is who has to prove their case is the simplified way to define this. And so this would be which party needs to prove their case and show that their position is more likely true than not based on the evidence. So in some cases, there are specific laws that apply. But if a specific law doesn't apply, basically the person who asserts the truth of claim has the burden to prove their claim. And so courts have interpreted this to mean if a person is having services cut or reduced, then the burden is on the agency to explain why they cut that. Now, if the person is seeking a new service or an additional service, the burden would be on the person to prove their case. And this can be pretty important as far as preparing for a hearing. Because if the burden is on the county, then the agency has to explain exactly why they came to this change. Whereas if you're asking for that new service, then you need to prove your case. And that means really making sure all the boxes are checked off for what's required for that specific program. For example, meeting every criteria for caddy waiver eligibility. And then another statute I'll quickly cover here is there are no costs for people to go to these hearings, but if you need to, let's say, plan childcare or pay for witness to attend, there is in statute a process to ask the county to cover those necessary and reasonable costs. And so, with this, best practice is to ask the agency before the hearing as soon as you can. And then if the agency refuses, then let the judge know. And if you do make that request, make sure you keep receipts and things like that. So I think this is a option a lot of people don't necessarily know about. And then, quickly, I'll just note that hearings are done by phone generally, but you can request an in-person assessment or video conference hearing. And interesting, there are two statutes cited here that Dalaine and I were just looking at before this, and they kind of note different expectations, but judges have kind of presented this to do in person. There needs to be a disability-related need for the in-person hearing. But video conference, I've found they're much more willing to grant that. So just know, they're generally done by phone, but you can request these other things. And then you do have a right to an interpreter if you need that for the process. No charge to you. And if there is no interpreter, then of course the hearing should be rescheduled. And then there are issues that come up where maybe you have a set hearing date and you're just not ready and need a different dates. So that's called requesting continuance. And you can ask for this, but you need to have a specific reason. Saying, hey, I just don't feel like going that day. That's probably not going to cut it necessarily. Usually they'll grant at least one request for a continuance. You might see the county ask that given times as well. That can be you're seeking legal advice, maybe witness is unable to be there, you need more time to get documentation, or the county didn't give you that appeal summary. Or maybe your health for you or your child becomes an issue. Those could be other ways to request that different dates. But I'd say one time you can expect them to grant that. Past that, it can be difficult, and depending on the case, they might not grant that. And so I know we're getting low on time here, but Dalaine, I think we really do need to talk through what the hearing process looks like, right?
Yeah. The hearing, it can be nerve-wracking, but really, the judge takes the lead initially, explains how it's going to go. The judge says, I'm a neutral party. I don't work for the county. I'm not representing the person. He swears you in. Even if you're on the phone, he asks you to raise your right hand and say that you're going to tell the truth. He reviews the evidence that you submitted, and he may put different numbers to the page numbers that you put in there. So keep that in mind, but he'll review that. And if there's anything he doesn't accept, he'll let you know. He often will clarify the issue. And then he'll give you time for opening statements if you want to make one.
Yeah, and with opening statements, it's not a must, but generally if you're going to do an opening statement, try to make it brief. So it could be, Your Honor, it could be something like, for example, Your Honor, we're here today because my CDCS budget was reduced from $20,000 down to $15,000 following a mid-choice assessment. And then we could argue that the county misassessed my need for supports with mobility. So just clarify what exactly you're asking for. So it could be asking for that budget to be restored to what it previously was, or it could be asking specifically what you want you're requesting your PC hours to be, provided you have that argument that supports it. And then you want me to talk about testimony, Dalaine?
Well, we
Yeah.
both can, I guess. The testimony is, I always say it's your turn to tell your story. But again, try to keep it, factual and keep the reasons, the legal reasons why kind of at head and center. And this is the same time when, well, you'll be able to, or if you have somebody help you, will be able to question your witnesses. They also will give testimony during this time. And if your opening statement says, this is the legal issue, this is correct, and I need my hours back, or I need my budget to be increased because I need the services, you want to incorporate that in your testimony. You and the judge can ask questions. The judge can ask questions anytime. It's important for you to kind of wait until the county's done speaking or others are done speaking and then ask, Your Honor, I have a question. And then at that time, he'll let you ask a question. And yeah, we already put the appellant's testimony. You are the appellant because you're being the one who appealed it, and stay specific. And then the judge will ask if you want to make a closing statement. And so I usually encourage people to keep that consistent with your opening statement. And maybe there's some things that come out during the hearing that even prove your points more, and you can reference that.
Yeah, and I will add, as far as testimony, it can look different depending on who attends. But most cases it's the when the county goes first, it's county staff explaining why they took the steps they did. So it could just be a narrative where they talk through their whole arguments. If they're represented by an attorney, let's say, it might be more of a question and answer form. And one thing I'll note, as far as similarly for appellant testimony, it could be you just have a narrative where you explain the whole thing, or it could be witnesses just coming up and explaining what their views are, or it could be question and answer. There's not one way to do it, but if there is an attorney involved, then it should be more of that question and answer. But let's say you're the only one testifying. You're talking about the issue. You're testifying, so that can be your time to tell your whole story. But many cases, if your closing statement's just gonna be the same thing as you already said, it probably doesn't make sense to do a closing statement at that point if it's just gonna be repetitive and not give the judge anything new. But if the county makes one and you want to respond to what they say, that could be one option there. And being in writing might make more sense if you feel like you need to cite to a lot of different documents in your argument, but it's not a must. And then, after the hearing, the judge doesn't make a decision the day of the hearing. And they'll let you know they're closing the record. So if closing statements are being done, then they'll leave the record open until certain dates. So written closing statements can be submitted. Maybe there's something where you didn't get a medical document you wanted, or during the hearing, you thought another document that'd be helpful to your arguments. You could also ask the judge to keep that record open for a little while longer to submit more documents. But if you do that, the judge will likely give the county a chance to respond to what you submitted in writing. And then that starts the waiting game, which under statute, it's supposed to be within 90 days from the appeal. But can take more time. In our experience, it's been taking a lot of time, and it's something our office has tried to kick around how to deal with that, because at this point there's no clear way to force DHS to issue these decisions sooner. And then let's say you get the appeal results. The first one you get the appeal back. First one is that the judge rules in your favor. Great. That's awesome. That the county could technically request reconsideration and say they disagree, or appeal the district court. But in practice, we rarely see lead agencies do that, or counties, I should say. But if you disagree, there are two options. One would be request for reconsideration, which is essentially a letter to DHS laying out and saying why you think they got it wrong. Now the key here, though, is the 30 days start from that final date that's written in the DHS appeal decision. So it's not when you receive it, it's that date in the decision. So that narrows the time to appeal, to request reconsideration. And to do that, you need to be able to show that they clearly misapplied law, which would be clear legal error. Maybe they stated a fact within the decision that changes the outcome completely. Or maybe since the hearing you got new information that you want to submit. Now, if you do that, you have to explain why it wasn't provided before. So that's a letter to DHS. So you don't need an attorney for that. Other step would be is an appeal to district court. That's one where I recommend you consult with an attorney because it's not as doable without an attorney. It can be confusing those processes. So yeah, I think that covered most of it. And then we've got some links to some resources, the CBSM, like we've talked about, the budget methodologies, if there's CDCS issues, Disability Services Division, and then some other places that might be able to provide advice or referral to help you with the process. And so, yeah, I think that's, unless you want to add anything about the resources, Dalaine, I just want to leave some time for some questions.
No, I think we've got a lot of questions. I thought I saw a long list, 36 or something a while back, so I don't know where we're at now, but do we have someone who's helping us weed through the questions?
We
And
do.
how-
Our chat monitors are going to step in and support the question and answer.
Oh, thank you so much, Jillian.
Yeah, I think this is Nora. I think the questions are really in a couple groups. Recourse options. What if, not helping, or if they lose certain paperwork? There's access questions, or questions around like what help is available. So I'm wondering kind of where you'd like to start. Around maybe some recourse?
Sure.
Sure. Yep.
So one is, around DHS lost someone's appeal. And so how, do you need proof of that for submitting it online? How do you get proof of that? And then how would you, what would be the recourse for a mistake on DHS end?
Yeah. So it's focused on it, a lost appeal request, right?
I believe
so. And so with that's why we really recommend people take a screenshot of you submitting that when you do, or if it's fax, getting that confirmation. And so if it's within that 90 days, you should be able to work through and they could still hear an appeal. But if it's past that 90 days, the option you won't have those options anymore because of state and federal law. They don't have jurisdiction anymore. So it means they don't have the ability to decide that case anymore. And so that's why we recommend following up with the county or with DHS to figure out, hey, was the appeal submitted? So it's in the 90 days, it shouldn't be too difficult to get to that point. But if it's past that 90 days, then your options narrow quite a bit.
Yeah, and I'll just add, I'm a phone caller. I'm a little old fashioned. And after I submitted a request for an appeal, I call them and I ask, did you receive this? And if they say no, not yet, I call the next day and I ask, did you receive it? Who's the judge? What's the docket number? And if I don't get, I'll call a third day. And if they don't get a third day, I'll resubmit my request to appeal. I'll just do the whole thing over.
Yeah, I mean, the big thing would be is keeping in mind that timeline you have. And so if you appealed right that first day you got it, I'd give it a few days or maybe a week just to see. And then if you don't hear anything, then just give DHS a call and check. But, if you're closer, let's say to that 30 days or that 90 days, then yeah, I also just give DHS a call and be like, hey, I'm calling, I submitted an appeal. I want to make sure, it was received. So, I don't think of many instances where they completely lose things, but, I still, you want to make sure, you check in on that and keep those timelines in mind.
Thanks for that.
Yeah.
Were there other questions that my colleagues kind of wanted to flag just because there were so many? I know there were. Yeah, go ahead.
Yeah, hi. There was a question from Rune. Rune, she has a 4-year-old daughter with nonverbal. Can you guys hear me?
Yep.
Yep. We can.
Okay,
Yep.
her daughter is nonverbal. The PCA, what they did the assessment, they only gave her 30 minutes. So I know 30 minutes a day, even though she has high support needs. So she sent for an appeal. She wrote down that today or yesterday, when she get to the appeal to talk to the judge asked what she needed. She was so nervous and scared because our community is scared with the judge and the counties, and she's like, am I in trouble? She said she froze up for like 13 minutes, like she couldn't talk. She had a little panic, and then the call ended. I mean, the meeting ended. She doesn't know what to do. I told her I could follow up and help her in this case, because there needs to be more. It's just more than the appeal, it looks like. So that was one of the questions from Somali speaking mom.
Yeah, and so I know it can be an intimidating process. Like Dalaine said, I still get nervous for these things. I've done many of them, and so I mean that'd be something where I'd suggest they figure out the contact information for that specific judge, and let it be known, that they feel they weren't able to present all their testimony and evidence, and they would like another hearing to add to the evidence. That could be a step to take to see if they're willing to do that. Dalaine, do you have any other ideas? But I would definitely want to follow up with that specific judge and let it be known. And
okay,
the sooner the better.
Yeah,
Okay.
the only thing I'll add is that I'm gonna put a resource in the chat. I think it's really important to focus on the PCA services are all about what help you need to complete your activities of daily living.
Mhm.
Dressing, eating, mobility, bathing or toileting. If a person's nonverbal, but they can do all of those things, then you have to show that they need help with those things. They need either hand-over-hand assistance, or they need constant cueing and supervision in order to qualify for those dependencies. So I'll put a fact sheet in the link.
Okay, I can tell her real quick. Rune abayo, and dadka hadda meesha ku jiro lawyeerinta waxay ku dhaheen wiilka wuxuu ku dhahay maadaama uu keiskaaga maanta cusub yahay, waxaa muhiima isla markii inaan ka daba wactano judgeka, maadaama waxba maanta aad mataqaanaa oo sida aad rabtid u dhicin oo follow up ku samaysay oo dhahda nervosa noqday, maanta waan isku dhex yaacay, keiskaan raba haddana inaan ku noqdo. gabadhana marka waxay ku tiri markaad BCA oo kale aad weydiisanayso judgeka cunugta 4 sano jirto oona hadli karin, waa inaad ka hadashaa wax nolol maalmeedka maxay qabsan kartaa, ma u qubaysaa, adimaa dharka u geliya, adimaa cuntada siiya, wax walba soo adiga uma qabatid. marka mar walba inaad waxaas ka hadashid. warqaday hadda inoo soo gelisa halkan ku caawinayso meesha chatka, taa haddaa kili garaysa nambarkaygana waan kuu soo diray, qoro saan kuu caawina insha allah. yaa walaal
insha allah baa laakiin waxay ugu tiri judgeka waxay ugu dhahday kiiskan waa xiran yahay, wixii information ahna waxaa kala soconaysaa oo micnaha go-aankii aan gaaray mailkaan kugu soo diraa bye.
Okay. The judge said this case is closed. All the decisions will be mailed out to you. And that was how the call ended. There was no decision. Nothing was made. So I don't know what that means. Yeah.
Yeah, I mean, generally they do say it's closed, but I have seen instances where, if there's a clear reason, especially if it's pretty recent after, that they're willing to take another look. It might be tough though if they said they already closed it, but I would suggest they make that request, and let's say they say no to that, that'd be a good reason for reconsideration to argue, hey, the judge didn't give me my opportunity to submit all the evidence I wanted to.
Okay. wuxuu ku dhahay judgeka ba marka qaarkood go-aanka wuu iska gaaraa oo wuu xiraa, laakiin adiga inaad ka samirtid ma aha. waad u qoran kartaa, waan wici karnaa, waxaan dhihi karnaa judgekii maalintaas aniga ma aanu helin waqti aan keiskayga iyo waxaygii dhibaatadayda aan ka hadlo, marka in jaanis labaad la isiiyaan rabaa, marka taas inay ku ogolaadaan laga yaabaa.
insha allah bye, thank you, insha allah kula soo xiriira qaali.
Haye macaan, haye. Okay, thank you.
There was another question too from Selby, who's here. Selby, ¿quiere preguntarle?
Okay, thank you. Yes, my daughter is 22-year-old. MAI assistance and waiver services were taken away because she does longer meet financial eligibility or participation criteria. While she has a MA qualifying immigration status, she has not fulfilled her 5-year waiting period. We have already appealed, and this was the decision. So, do you have any recommendation what we can do to move forward? At least keep an MA or get other resources. We still have case manager, but she told me there is no services offered for my daughter.
Chad, I'm fielding this one to you.
Yeah, I mean,
That's
you know, I
complicated.
hate to kind of not answer the question, but I can't really get into specific cases here, and that's kind of creeping into that area where if somebody wants help, I'd have them give our office a call. Just because I don't want to make assumptions about immigration status, things like that. And so, you know, unfortunately, I can't answer that one here. I don't know if you have anything else to offer, Dalaine, but I feel like we're getting pretty specific.
I'm gonna just send a chat message to, is it Selvie?
Selby, yes?
To Selvie directly, and I'll just give you my name, and we can't agree for sure to accept the case, but you can send me the details and I'll review it with our team and see if we can look at that.
Okay, thank you so much.
Yeah, yeah.
And another thing, I will appreciate it will be soon, because we also received them. We have only from to Wednesday to this Friday to the judge sent us like a letter to the county if we have another information to add to the case. So, but she give us until Friday 1st. So I appreciate if we can get in touch before this Friday to answer some things or to do something.
Yeah, and Selvie, I'm just gonna ask, you can email the county and ask for an extension. Ask for a week extension and say you're trying to get some legal advice. Just
Okay.
ask for a week extension and see if they say yes or no. That'll give us a little bit of a cushion.
Okay,
Okay.
thank you.
Yeah, sorry to give that lawyer answer there, but you know, if we're getting into specifics, you know, more specific advice on a case, I would need to, you know, review the facts closely to make sure our advice makes sense.
This is Jess from Gillette Children's. I'm going to read a question in the chat from Anissa. She says, another question about the exception or budget increase by 30%. If you were granted one the previous year, I understand you can request another. Is a request for more hours for support staff reason alone to request this increase?
I'm just going to interject before we answer this question and just to ask, since we have gone over time, we have had to have several of our interpreters leave. So please bear with us as we continue to answer questions, and we do apologize if we don't have an interpreter available for your language preference.
Yeah, I think that the primary reason to request a reassessment is that there's been a change in condition or a change in circumstance. So Chad, I don't know, that's my understanding of the reasonable reasons to request a new assessment. Are you familiar with others?
Can you read the question again for me?
Yes, it says another question is about the exception or budget increase by 30%. If you were granted one the previous year, I understand you can request another. Is a request for more hours for support staff reason alone to request this increase?
I was the one who asked the question. Can I just clarify real quick?
Sure.
That's what you were saying about like specific questions and not to go too deep, but I think my overall arching question is, can you request an appeal for the mint choice assessment well into the budget year? Like I think we're into month 4 or 5 now. And can you request like you were going over some of the criteria for the assessment, can you request the scores and the assessment and kind of go back to it in month 4, or should you just wait until the next assessment?
Oh, great. Thank you for clarifying that. That's, a great question. And, with that, that goes back to the timelines to appeal. And so at that 4 months, unfortunately, that would be past that 90 days good cause. And so with that, I would usually advise someone to wait till that next assessment. But like Dalaine said, if there's a huge change in needs during that time, ask for that. It doesn't necessarily mean the county will grant it, but that could be another method to deal with that. But yeah, once you're past that 90 days, then the appeal process is going to be the way to resolve that issue necessarily.
Another question in the chat from Stephanie. Do you have to list the county employees in a witness list? What if the county employees see that you are calling on them and they decide not to attend?
Yeah, I mean, that's a good question. And, in a lot of cases, it's, this is my view anyways, it's almost better if the county staff don't appear, because then they don't have that, let's say the assessor doesn't appear. They don't have that person directly testifying to what they experienced then. But if there is a staff person you really want there, from the county, you can let it be known that you want them as a witness. And if they won't, then, you can ask the judge for a subpoena to require that person to appear. So that would be one way to have them appear. But I would to subpoena a county witness, think you'd want a specific reason why you want that person. Now, let's say maybe that staff person is really supportive of you in the process, then maybe would consider subpoenaing. But I would worry that if you subpoena them and push comes to shove, they're gonna go on the side of the county. But that subpoena process could be a way to do that. So there's a way to require them to attend.
I agree.
Jonathan asked if you need queuing and body doubling to start IADLs and to troubleshoot when you run into problems. How do you explain?
Can you read that again? I'm not sure if I understood the question.
Yeah, and Jonathan, if you're here still, can maybe clarify?
If you just don't, I guess the things never happen, like your cares never happen if you don't have the body doubling and the troubleshooting when things break down. I'm and a number of my friends fall into this category, and during MN choices, that always or almost always gets interpreted as you don't need hardly any PCA hours because you can sometimes do the thing. And but most of the time you can't without that support. So I guess, do you have any resources to help us push back? Because often it's really hard to advocate for that ourselves.
I really appreciate that question, Jonathan, and I think it reflects how many of us have disabilities that kind of ebb and flow. We have good days and bad days. I think getting if you can, some type of documentation from a medical professional or a therapist or even a physical therapist or occupational therapist that kind of lays out what your limitations are and why you need constant cueing and supervision. And it's hard because all of us want to reflect positively. So usually when you're with an assessor, you want to say, oh, I'm doing really good. And oh, of course I can do that by myself, but some days I can't. And the truth of the matter is, to qualify and be eligible for the service, you kind of have to present what does it look like on your worst days or your tough days, and you have to bring some evidence forward that's going to show and going to kind of prove that. And sometimes they won't take the evidence from your current PCAs because they'll think that's a conflict of interest because they're getting paid to work with you, right? So if you have any other parties involved in your life that can bring witness forward of what those assessed needs are and how difficult that is for you and why you need that constant cueing and supervision in order to sustain your wellness and to maintain your independence. I think you have to frame it, and if you can get medical documentation or letters of support and evidence and witness from other people, that can be really helpful. But we certainly understand how difficult that is, and we deal with that in a lot of our appeals.
Thank you.
Yeah, I mean, I think your question and comments, I think, sum up flaws in the system itself. You know, I've always episodic disabilities where they can change. You know, just the way the statute's written, it doesn't pick up on those things like they should. So, you know, that goes towards, I mean, summing up what those worst days look like for supports. You know, to put that home during the assessments. But you know, I guess it's something where I wish it was, you know, better defined there of, you know, what the supports are. And so, I mean, a case like that, you know, assuming, I mean, I don't know specific people, but if somebody's qualified for a waiver, there could be ways to get those supports that don't connect directly to that PCA connection. It could be, you know, IHS services or personal supports, things like that. And so that could be something to consider.
And the new CFSS is supposed to, I think, allow more flexibility. That PCA is switching to the CFSS for some of those additional services. Is that, I mean, that's the commercial that I'm hearing, Chad, but you're looking doubtful.
Yeah, I guess I've seen practice. I just am doubtful. But you know, maybe I'm mistaken though. So
shoot.
Marin just asked me just to explain body doubling, and body doubling or parallel play is just having someone there to help you activate your mirror neurons and do the thing with you. Often vibing next to somebody, even if they're doing the same thing, really helps you through your day. And then when you get stuck or your body just doesn't tell you to drink water, they can remind you about the 30-minute water rule so you don't, you know, start doing really poorly in a couple of hours. That just keeps you functional.
mm-hmm. Yeah,
Keep
thank
you
you for explaining
functional
that.
as needed. Yeah, thank you for explaining that.
All right, any other questions?
We have one more question from Stephanie, and apologies if you've answered this already. She asked if something is stated a bit different in the CBSM than Minnesota statute, which do you go with?
Yeah, statute for sure. Because the CBSM we found doesn't always get updated in a timely manner to do that. And so that's why the CBSM is a good starting point, but asking county to provide those citations, and the CBSM should link that specific statute. So you're right. I mean, so yeah, statute should come first before DHS policy. Absolutely.
Well, what a great set of questions. We are so grateful to our speakers, Dalaine and Chad, for sharing their expertise with us today. We're grateful to our interpreters for helping us with accessibility, and we'd also like to thank our co-hosts for helping us create this event, including Minnesota Autistic Alliance, Gillette's Children's Specialty Hospital, the ARC of Minnesota, the Autism Society of Minnesota, Down Syndrome Association of Minnesota, Proof Alliance, Mongar Global, Family Voices of Minnesota, Minnesota Parents United Stand Up, Mongar Voices, Te Apoyo, Multicultural Autism Action Network, and a special thanks to our partner, the Minnesota Council on Disability, for providing ASL interpreters. And finally, we would like to thank all of you for joining us for this important discussion. If you need help or more information, please feel free to reach out to any of the advocacy organizations we just mentioned for additional support. Thank you and good night.
Thank you, Jillian.